Hello everyone. My research topic is about drunk driving issues that deal with the First Amendment. This presentation provides an overview of the controversy and some relevant information about it. The controversy refers to a federal court case, Birchfield v. North Dakota. In 2015, a driver named Danny Dakota was stopped by some police officers to take a chemical test because they believed Dakota was intoxicated. However, Dakota refused to submit to the chemical test, so he was arrested for violating the state law. Dakota complained that the state law violates his First Amendment rights against unreasonable searches and seizures. Let's go over the First Amendment. The first part of the amendment says people's privacy and property should be protected against unreasonable searches and seizures from government. The second part states, in order for police to get a warrant, he must show the judge probable cause, the standard by which police authorities have reasonable grounds. Dakota complained he had right to see the warrant before submitting to the chemical test. He also argued this search was unreasonable because it was warrantless and infringed his privacy. Here are some questions from Dakota case. Do you think police officers had to get a warrant before asking Dakota to take the chemical test? And do you agree with Dakota that the search was unreasonable? Before finding answers to the question, let's see a quote from Porter Stewart. This quote gives a fact that not all searches and seizures are protected by Fourth Amendment, only those unreasonable ones. That means if the search is reasonable, it should be legal and doesn't violate the Fourth Amendment. In order to prove the search is reasonable, my first argument, the search promotes public safety. Assuming drunk drivers get free of penalties because the search is unreasonable and prohibited, they are likely doing the same thing. This threatens other people's lives. Our society also becomes more dangerous. That's why the search is essential to public safety and should be considered reasonable. My second argument, warrantless search was legal in Dakota case. There are two reasons to support my argument. First off, getting a warrant takes some time. The result of chemical test can be totally different after police officer gets a warrant. Scientifically, the concentration of alcohol in Dakota's blood can be lower. Under this special circumstance, it's unrealistic to get a warrant. The second reason, police didn't ask Dakota to take a chemical test for no reason. They must have reasons and evidence to show their judgment and sense were right. Maybe from his smell, behavior, or even from police officers' experiences and intuition. This can be used as a probable cause to get a warrant. Therefore, I believe the reasonable search plus unnecessary warrant should be equal to the search is constitutional and legal. Furthermore, it implies any drivers who refuse to take the chemical test should be criminalized. My thesis statement is also the conclusion of my arguments. States should be granted the power and authority to criminalize a person who refuses to submit to chemical test because it doesn't violate the First Amendment. The second part of my thesis statement gives more supporting evidence to my arguments. First off, the search provides useful evidence for police to determine whether the driver is guilty or not. Secondly, It educates drunk drivers and prevents further drunk driving incidents, which is positive to the society. There are some things that inspire me to choose this topic. First, this case is very controversial and debatable. Some people would think Dakota was right and police shouldn't conduct the warrantless search. Some believe the search is appropriate. It also deals with real-life issues. Many of us would encounter similar issues. On the other hand, I also find this case very interesting. I'm curious to know the development and result of the issue. It's also on the news. I chose this topic also because the decision of the Supreme Court affects many people in the nation. It gives answer to whether a warrant is needed before police conduct the search. People's perspectives and stereotypes towards First Amendment will be changed. It also has significant influences on the society, whether our society will become more dangerous or safer. So far, I have written 5 pages for the research paper. I need more details and credible resources to support my points. And still, many of my ideas and points are not so organized. I will keep working on that and get 7 pages done by this weekend. I will also go to tutoring center. Here are some outside resources I found. The first one is the fact warrantless search has become common and popular today. I found this source in Saddleback Library. Both authors are professionals in the field of law and justice. That makes the source more credible. The strength of this source would be it supports my argument warrantless search can be legal. The weakness would be this source would be better if it's supported by statistics and evidence. I will definitely use this source in my research paper. The second source explains the police can conduct a search if he believes someone or something is suspicious and unusual. There are no offers for this source, but the publisher, United States Courts, is authoritative and credible. There are also some precedent court cases to support the credibility of the source. The strength of the source. This statement is credible. It supports my argument that if police has probable cause, he can conduct the search without a warrant. It's also supported by precedent cases. I haven't found any weakness about the false. I will use these false in my research paper. In conclusion, the search in Dakota case is constitutional and appropriate. The state law doesn't contradict with the First Amendment.